Good morning, everybody, and welcome to another episode of LJ Law Family Law TV. My name is Bonnie Leonardo, and I am your host. Today's topic deals with inheritance. Can my spouse get part of my inheritance in a divorce? Is a question that I deal with sometimes here in the office. The first thing that I would like to explain is that because Nevada is a community property state, any assets that are obtained during the marriage are considered part of the marital estate and may be subject to equitable distribution. Any other property is considered separate property and therefore is not subject to division between the parties. Inherited assets are considered to be separate property and therefore they are not subject to division between the parties normally, usually. An inherited asset that is given to one person is not part of the marital estate normally. Let me explain what I mean by this. This inherited assets can be a tricky situation. What's important to know is that while the inherited asset at the inception is considered to be separate property unless it is given to both parties and names both parties, this can actually quickly change if the inherited asset is commingled with marital assets. So for example, if you receive a large sum of money as an inheritance, but to you only and not your spouse, but you place that money in a joint bank account with your spouse, then immediately you are commingling that inherited asset, and now you are changing the definition of the asset from a separate property to community property. Also, for example, you inherit a home and it is only in your name, but if your spouse puts significant amount of money into the house, makes significant amounts of repairs to the house, thus increasing the value of the home significantly, then now that home changes status from a separate property to a community property to some extent. So if commingling does occur and the inherited asset is now deemed to be a community property, it will be a very difficult battle and a high burden of proof for the spouse receiving the inheritance to prove to the court that the commingling was not, did not have the intention of changing the designation of that property from separate to community. So remember, in order to keep your inheritance, and to continue to make it a separate property, do not commingle it with any marital assets. Do not put it in a joint bank account. Keep it in a separate account that is only yours and that you only have access to, so that it does not accidentally become a community property if you wish to keep it as a separate property. If you have questions about this topic and want to discuss it further, or if you have questions about any other family law topic, go to vegasdivorcemeeting.com and I will be happy to sit down with you to discuss your situations more at length. And as always, I thank you for watching and I will see you guys next time. Bye-bye.